Welcome back to part 5, chapter 3. In the previous video, we spoke about rights, duties and powers of a bankruptcy trustee and the bankrupt. Now we also ended by the previous video by saying that it's not an unfettered right for a bankruptcy trustee to do whatever he wants. So, there is a section called section 153 which speaks about the approval of the committee of creditors for certain acts. The bankruptcy trustee may, for the purpose of this chapter, it uses the term after the approval of the committee of creditors, perform the following acts. Again, there are 9 acts that are specified. So, I've attempted to actually classify it into 3 bundles. One which relates to a suit, legal proceeding, compromise or arrangements. So, you can start with B. You can mark it as 1. Bring, institute or defend any legal suit or proceeding relating to the property comprised in the estate. F. Refer to arbitration. Here there is a reference to arbitration or compromise on such terms as may be agreed, any debts subsisting. G. Compromise or arrangement with reference to creditors. Compromise or arrangement with reference to any claim. So it spoke about a legal suit or proceeding, institute or defend. 2, it spoke about referring to compromise or arrangement on debt. 3, make compromise or arrangement on creditors. 4, make compromise or arrangement in relation to claims. Then you come to the next. These 3 deal with actually getting value. So, and they relate to assets. So you can take on mortgage. D. Mortgage or pledge any property for the purpose of raising money. Where any right, option or other power forms part of the estate, make payments or incur liabilities with a view to obtaining for the benefit of such creditors any property which is the subject of such right, option or power. And the third thing is accept as consideration for the sale of any property a sum of money due at a future time subject to certain stipulations as security. Right? So these 3 relate to recovery of sale proceeds where it's a future sale, 2 pledge hypothecation and its relevant raising money, and 3 in relation to rights and options. Then this is a standard clause. To carry on any business of the bankrupt as may be necessary for winding it up beneficially. That's your point number 8, which is clause A. And the last is clause I. It says with the approval of the committee of creditors only, you can appoint the bankrupt to supervise the management of estate of the bankrupt, carry on his business and assist the bankruptcy trustee in administering. In the earlier part, we said the rights of the bankruptcy trustee, he can employ anybody. But if you want to take your own bankrupt to help you in the administration, it starts by saying after procuring of the approval of the committee of creditors. Please remember there was a legal suit or proceeding. There were 3 things in relation to claims. Then there was there was 3 things to do with property and 2 to do with beneficial winding up and using the bankrupt himself. Then we come to section 154. Which is vesting of the estate of the bankrupt. It shall vest with the BT immediately from the date of his appointment. It uses double emphasis. Immediately, the date of appointment. The vesting shall take place without any conveyance, assignment or transfer. That's because your BT is getting appointed in this process, right? And then the BO is given. Estate of the bankrupt, section 155. The estate of the bankrupt. So what's that? It's a creation. It should include all property belonging to or vested in the bankrupt as at the bankruptcy commencement date. So it's belonging and vested. Now you go to C. Any property which by virtue of any of the provisions of this chapter is comprised in the estate. So later, anything which is going to be comprised, like for example, you get some money because of a after acquired property or an arrest property. Then that also comes here. B. The capacity to exercise and to initiate proceedings for exercising all such powers. The estate shall not include, this is a very, very important point, it shall not include excluded assets, assets held in trust for any other person, any sum due to any workman or employee from the Provident Fund, Pension Fund or Gratuity Fund, and such other assets. These categories of assets shall not be included in the bankruptcy estate. Delivery of property. So bankrupt, banker, agent, any other person possessing property is required to, transfer this to the bankruptcy trustee. It doesn't use the word transfer, it says deliver. So on the other side, bankruptcy trustee shall take possession and control of property, books, papers, records relating to the estate of the affairs of the bankrupt or the affairs of the bankrupt, which belong to him or in possession or under his control. So there's both custody and control of everything. Property, books, papers and records, everything. Right? Where an estate of a bankrupt consists of actionable claims. So I have got a court decree in favor of the bankrupt. They shall be deemed to be assigned to the bankruptcy trustee without any notice of the assignment. So till this, we finish this one part, which is basically the creation of the bankruptcy estate, actions that can be done only with the approval of the committee of creditors. Then we go to one more. See, once the bankruptcy estate has got created and there's a BT in place, we have to remember that any application, okay, this is not exactly related to my former statement, it ends there. Now 158 speaks about disposition of property. See, where any debtor disposes of property between the date of filing of application for bankruptcy and the date of the bankruptcy commencement date, it shall be void. Please remember, from bankruptcy application date to bankruptcy commencement date, it's void. However, if any person has received it prior to the bankruptcy commencement date, okay, here they don't use application date. So it was application date to bankruptcy commencement date. If any person has acquired it prior to the bankruptcy commencement date, okay, in good faith, value and without notice of the application for bankruptcy, then there is no right against such person. Okay, and here property includes property whether it is comprised or not comprised in the estate of the bankrupt, but shall not be including the property held by the debtor in trust or for any other person. Okay. So any disposal of property from the date of application to the date of bankruptcy commencement shall be void. After application but before bankruptcy commencement, if it was good faith, for value and without notice of application for bankruptcy, then you have no rights against that person. But most important here is the value should have been received. So if the value is received, it's fine. Right? With this, we stop here at 158. And in the next segment, which is a very important segment, we will go through 6 different kinds of transactions which will come under this avoidance purview. So they are after acquired transactions, onerous transactions, disclaimer of leaseholds, undervalued transactions, preferential transactions and extortionate credit transactions. The mnemonic is AODUPE. AODUPE. Okay. Look forward to the next session, Sharanya. Bye.